Hello everyone, so I'm George from Ireland and this is my English law channel. So this video is going to be about the separation of powers. Anyway, so the three branches of government are the legislature, which makes laws or legislation. Then there is the executive, which gives orders, as in execute it. To execute doesn't necessarily mean kill, it just means do it. Okay, and number three, there's the judiciary, as in the judges and the courts. So you've got the legislative branch, the executive branch, and the judicial branch. So there's this idea that no branch should be overmighty. So we don't, and they shouldn't intrude into each other's space. The system of checks and balances, so nobody becomes too powerful. This is what Montesquieu had to say about it in 1748. When the legislative and executive powers are united in the same person or in the same body of magistrates, there can be no liberty. There is no liberty if the power of judging is not separated from the legislative and the executive. Then there will be an end to everything if the same man or the same body were to exercise those three powers. Close quotations. So that's the spirit of laws. So there would be obviously abuse of power. Has the executive gone ultra vires? Well, I'm the executive, I'll get the court to sit on that. Or, well, I'm the judge who's deciding, so of course I'll find in my favour. Has the legislature done something wrong? Well, that goes to the court again, but I am the court and as well as the legislator. So it could be very self-serving. There'd be clearly a conflict of interest and of loyalties there. So the executive is kept in check by the judiciary to see that the executive does not exceed its powers. We've got judicial review. The legislature creates laws or indeed repeals old laws. The judiciary interprets those laws. So the judiciary have got to be independent of the government, but also the opposition, to rule without fear, without favour, to be neutral, to be detached, dispassionate, to be like a referee in a sports match, and not to be interfered with by the government. They can't be sacked because they made inconvenient decisions. They can't have their salaries reduced. They can only be removed if they commit a crime. So the Constitutional Reform Act of 2005, it furthered the separation of powers. The Supreme Court was set up. The Lord Chief Justice became head of the judiciary. It was no longer the Lord Chancellor in England and Wales. A statutory duty was imposed on ministers to maintain judicial independence, and they provided for a separate judicial appointments commission. Previously been this murky system of soundings, and people said there's too much favouritism. This is how the judiciary was impacted by this attempt to really copper fasten the separation of powers. So in the United States, you'll find that system as well. You'll find it in the German Basic Law, Article 20, or under the Basic Law, Article 137. A member of the German Parliament, the Bundestag, cannot be a judge or a civil servant at the same time. So let's look at the rule of law. So again, this is a key constitutional concept, and this is to make sure that the body politic is healthy. Well, there's no easy definition of the rule of law, but here are some of its criteria. A citizen can only be punished if he is proved guilty to have committed a crime in a fair trial. So that's also habeas corpus, literally, do you have a body? So we can't put people in jail forever and not present them in court for a trial. No one is above the law, it applies to everybody. That even the Queen, monarchs have been put on trial before. So regardless of your wealth or what social class you are, your ethnicity, your gender, your sexual orientation, so on, your citizenship, you have the same rights. So the rule of laws goes back to Aristotle's time in the 3rd century BC. So Dicey wrote about it a lot. So according to Albert Venn Dicey, there were three aspects to the rule of law. And he said there were the following, that people can only be penalised if they've broken a particular law. We can't say, you've broken the law. Which one? Tell me which law, which crime I'm being charged with. And they have to have a fair trial in a court, and you've got to follow the correct procedure. Second of all, everybody is subject to law. So that includes all social classes and even the monarch. And third of all, the constitutional principles arise from common law. So this is Dicey's theory about it. So anyway, there are other theories which are more extensive than this, more ambitious, and they would say that fundamental human rights are also part of the rule of law. So Lord Bingham, who died some years ago, he produced a magnificent but very succinct tome on this entitled The Rule of Law. And in the preamble, he says, the trouble is people always say, blah, 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 rule of law, which is really hurrah for our side. So he gave a brief exegesis of what rule of law actually means. This is one of the things he wrote. All persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly made, taking effect generally in the future, and publicly administered in the courts. Close quotation. So that's what Bingham believed. Another thing about Bingham is he said, that, I can't think what it is. Yes, so no retroactivity. That's a well-known principle. You can't say that eating ice cream from yesterday was illegal. That you're just passing the law today. But if I had ice cream yesterday, it was not a crime at the time. I had no means of avoiding the criminal being this criminal liability because I didn't know it was going to be retrospectively criminalised. So here are the 8 principles which Bingham says encompass the rule of law. Number 1, that the law must be accessible, lucid, and predictable. So we actually know what it is. And number 2, issues of law and liability ought to be usually resolved by applying legal principles and not by discretion. So that we can't have too much arbitrary power in the hands of judges. And he did say usually that there is some scope for a discretion. Sometimes it can't be avoided. And number 3, the laws are applicable to everyone except where objective differences warrant differentiation. Okay, there could be something as a positive discrimination, which might be okay. We might have a lower retirement age for women than men, and suppose that's justified by some objective difference, and so on. Number 4, so the laws must uphold human rights. Number 5, that we must have a way to resolve civil disputes which are not unduly expensive or slow. Number 6, ministers and all public officials should exercise their powers reasonably and in good faith and for the reason which the powers were bestowed upon them without going beyond their powers. He gave an example, this guy called Walter Wolfgang, he stood up in the Labour Party conference and he heckled Tony Blair. He was arrested and charged under the Terrorism Act. And Lord Bingham said that's ridiculous because the Terrorism Act was to prevent just that, terrorism as in killing people. And this man, Wolfgang, wasn't killing anybody, he was interrupting somebody's speech. And number 6, that there's adjudicative procedures that created by the state ought to be fair. Equality of arms in court, you have a right to speak into defence. If you can't afford a lawyer, you get one for free, and so forth. And number 8, the state must abide by its own obligations that it's undertaken pursuant to international law. Okay, so that's the end of his 8 principles. Anyway, so let's look at more of the importance of the rule of law. So there's the World Justice Project, which analyses to what degree different states meet these requirements of the rule of law. So it's an estimable organisation, and it seeks to further the rule of law globally. So it has a rule of law index, and each year it says where the countries are, and they rate 126 countries. There are 193 in the world. So the World Justice Project is really vital because it makes us freer, richer, happier, healthier, all the rest of it. Where there is no rule of law, you can think that the tyranny prevails, that you don't get medicine, there are terrible public services, there's a kleptocracy, public money is filched by corrupt officials and politicians. There's a lot of crime. You could be accused of crime you didn't commit, you wouldn't have a fair trial. You can be convicted of something you blatantly didn't do. You can get decades in a horrific prison. You can get the death penalty when you did nothing wrong. Torture is rife. There's severe racial and sex discrimination. People don't want to invest in your country because they've got no faith in the judicial system. There's no, security of title. Your property can be sequestrated arbitrarily. So it leads to gross inequalities. So rule of law is really the polar opposite. It minimises corruption and bribery. It leads to better public health outcomes, to education for all. It reduces penury, and it saves you from injustice and tyranny. So that ought to be an objective of all governments, civil society, and so forth. So this World Justice Project, it went further. It said that rule of law systems are those where 4 key principles are respected. 1, the government and all its agents can be held to account under the law. Number 2, that the laws are lucid, they are published, they are fair, and they are applied in an even-handed manner to uphold people's human rights, including security of person and property. As in, you can't be jailed with no good reason, you can't have your property taken away from you without good reason. Number 3, the process by which laws passed are transparent, and they are also enforced in a fair, predictable, and effectual manner. And number 4, that justice is done reasonably promptly by well-qualified and ethical, genuinely independent judges. Okay, so that's the end of their 4 principles. So if you don't have these things, then there'll be a sclerotic system, and cases will take 20 years to settle. Even then, can't be sure of the outcome. That's why in Russia, Russian companies often say this contract will be governed by English law, because they don't trust their own courts. Or in Pakistan, cases can take decades, and again, you can't be sure of the result, because the judge may well have been bribed. Witnesses may well have been intimidated. Not to say there are no problems in England and Wales, there certainly are, but they're not so severe or widespread. So anyway, some people say that the rule of law, this phrase is effectively meaningless. So Brian Tamanaha remarked, "It is necessary to maintain a sharp analytical separation between the rule of law, democracy and human rights, as well as other good things that we want, like health and security, because mixing all these together tends to obscure the essential reality that the society and government may comply with the rule of law, yet be seriously flawed or wanting in various respects." Close quotations. India might be an example. It does have rule of law, and yes, it's made a lot of progress recently, but it's not to say that there's no pauperism there. There is, and maybe rule of law slows things down. It pauses government. It makes it too feeble and unable to tackle problems. Whereas a totalitarian society like China is twice as rich as India. It's got better economic growth. The problem they can just sort of solve things like the Gordian knot. They just go through it very, very rapidly and decisively. So because of the requirements of the rule of law are so onerous and wide-ranging, it's hard for these to all be achieved. So the World Justice Project looks at constitutions and looks at how well civil and criminal systems function. They also examine alternative dispute resolution and look at the legal culture. So we're looking at English criminal and civil law and how these standards are applicable. So we have to consider to what degree institutions and process of the English legal system adhere to these requirements of the rule of law. So anyway, the people often are trying to make the system better, and you should think, how could we make it better? Ridiculous to pretend it's perfect. But this is what the Lord Bingham had to say about it. The concept of the rule of law is not fixed for all time. Some countries do not subscribe to it fully, and some subscribe only in name, if that. Even those who do subscribe find it difficult to apply all its precepts quite all the time. So, close quotation. That's from his 2011 book, The Rule of Law. But going on a little bit further, so look at the independence of the judiciary. So the Bangalore Principles of Judicial Conduct were promulgated in 2002, and they say the way judges should behave, not to be taking bribes, to be making its decisions objectively, and not out of prejudice, liking or disliking any individual, any ethnic group, any religion, any sex, any sexual orientation. So really doing it on the facts and being unemotional. So the first principle is judicial independence is a prerequisite to the rule of law and the fundamental guarantee of a fair trial. A judge shall therefore uphold and exemplify judicial independence in both its individual and institutional aspects. Close quotations. So if the most unpopular man in the country is on trial, if he's not guilty of a crime, he must be acquitted, even if he's hated by everyone. If the most popular woman in the country is on trial, but she is actually guilty of that crime, then she must be convicted, even if everybody loves her. So that's it. There's the United Nations Office on Drugs and Crime. So the judicial independence is a responsibility of each individual judge to allow him or her to deal with things honestly and in good faith. There must be impartiality. They must be free from outside pressure or influence, or saying, yeah, but don't you support this political party? But if you make that ruling, it'll look bad for our country. But if you make this ruling, people will say you're prejudiced towards that group of people. Or if you make the opposite ruling, people will say you're prejudiced in favour of the other group of people. whatever you do, you'll be accused of something, of prejudice for or against whatever group. Just put that in mind. Don't let that worry you. Don't care about public relations. It doesn't matter how it looks. You do justice. Whatever you do, you'll be accused of something. As a judge, you do the right thing. So judicial independence means that judges and the judiciary as a whole have to decide cases based on the law, and they should not be interfered with. And it would be deeply inappropriate and unbecoming of politicians or anyone else to try and have a word in their ear, to nudge in this way or that way. So pressure groups, other judges, should not intrude in this judicial process. But anyway, is it always really like that? We want to uphold public confidence in the whole system. And the media may campaign this way or that way, or quite shockingly, I think it's the Daily Mail, called the Supreme Court enemies of the people. I hope the Supreme Court didn't let them weren't swayed by that. So anyway, the constitutional position of judges is a contentious one. And the judiciary interpret legislation, and sometimes they make decisions which are unpopular and inconvenient for the government of the day. So they're adjudicating on the Human Rights Act and so on. So some people say the trouble is this forces them to intrude into the political arena, and they should stay out of the political fora. Anyway, but the judiciary, shouldn't they be accountable as well? How can we assume they're neutral? How do we know? We don't. Why should we take it on trust? So the role of the judiciary in adjudicating disputes between citizens and the state has become all the greater in recent years. And they also have to defend people from unlawful actions by the government. Lord Phillips was the first president of the UK Supreme Court, and in 2011 he said this: "The citizen must be able to challenge the legitimacy of executive action before an independent judiciary, because it is the executive that exercises the power of the state, and because of the executive that is the most frequent litigator in the courts, it is from executive pressure influence the judiciary are particularly to be protected." Close quotation. So suggesting external agents and ordinary people, they seldom pressure the Supreme Court. Anyway, just because the government does something, that doesn't automatically mean it's legal. The courts can block it. So we need to have an independent judiciary. So the statutory legislation is provided for. The Constitutional Reform Act, Section 3 says the following: "The Lord Chancellor and other ministers of the Crown, and all with the responsibility for matters relating to the judiciary or otherwise the administration of justice, must uphold the continued independence of the judiciary." Close quotation. So the duties thereunder are that the Lord Chancellor and ministers mustn't seek to influence judges one way or the other. Moreover, the Lord Chancellor must be cognizant of the need to uphold judicial independence and the need for the judiciary to have the support that they require in order to discharge their duties. That's enough from me. Toodaloo.